Hello there, my dear friends. Welcome to our sharing on Philippine law. And this is dedicated especially for all the Filipinos who deep within their hearts wanted to be lawyers. I've encountered a number of people who come to me and confide in me saying, Attorney, sana po naging abogado rin akong katulad niyo. And I really have a very pleasant feeling because I was like them before I became a lawyer. A frustrated lawyer who wanted to say his piece, but probably I did not know how to say it from a legally acceptable standpoint. In fact, in my own role as a finance executive, there was one time I was trying to reconcile with an office associate who could not explain to me why my legal view cannot stand. And in his irritation, he said, "Bakit? Abogado ka ba?" And so I felt so sad because I was not. And he was challenging who am I to talk about my views when I am not even a lawyer. Parenthetically, I met this person a couple of years after that in a Makati trial court. And when he saw me in coat and tie, he was not sure why I was there because I was no longer a young man at the time he saw me. And he was even much older. And so he was watching my behavior until when the roll call was made and my case was called ahead, I stood up to say, Attorney Joe-Santos Balagtas Bisquera, for the as private prosecuting attorney under the guidance and supervision of the public prosecutor. And I was trying to glimpse at him and he was really so shocked. Ito palang sinabihan niya na, bakit? Abogado ka ba? Finally is there with him in the trial court as a lawyer. Anyway, kwento lang po sa inyo yon. I would welcome especially my bar reviewees, my law students at the University of Manila. We now are moving to remedial law and we will start with criminal procedure. And the criminal procedure has a very fundamental start, which is the Barangay Justice System. And therefore, I welcome you to this continuing session as part of our online law curriculum under this COVID-19 pandemic. I would also like to dedicate this to all the law students all over the Philippines who may find consolation that they are welcome to view these uploads on YouTube without any extra charge. And as I was saying, to all Filipinos who want to learn their law without having to pay any lawyer for any fee whatsoever. So to start the ball rolling, my dear friends, allow me to share with you some thoughts on the Philippine criminal justice system. Society's assurance of equality against the brute force of the jungle. Excuse me. Society values the fundamental concept that a person cannot be deprived of his life, of his liberty, and of his property. And I know all of you will follow this up by saying, without due process of law. Very good. You know and you love our Constitution. The state is called upon to protect society as a collective protective action in isolating and punishing social deviance. where an offense against a particular person is deemed as an offense against society itself. The Philippine criminal justice system addresses antisocial offenses defined in the revised penal code and all other special criminal laws and Supreme Court jurisprudence. And the people of the Philippines, if you notice, is the real complainant in criminal cases. The offended party serves as the main complaining witness, and so that therefore it is the people themselves collectively that gets offended when any person violates our criminal justice system, the offenses defined in the revised penal code, particularly against persons, against property, against honor, you know, and against liberty. Continuing now, allow me to share with you a very first flaw of how an offense is prosecuted from the time the offended victim makes a complaint up to the time that that particular complaint converted into an information is filed in court. And so here you will notice on your upper left hand portion the offended victim being carried. He appears to be alive so far and kicking, bound for the hospital. We don't know, he may finally die. And so, being the offended party, he triggers his complaint by filing this with the public prosecutor. And the public prosecutor receives the complaint and takes a look at the complaint in the process of undertaking his preliminary investigation. And the first part of his preliminary investigation is for him to subpoena and call the suspect named in the complaint so that due process will now start operating. There is a complainant taking issue that he was hurt by somebody, and the prosecutor gets into the middle because he will handle the people of the Philippines, and he now gives due process by calling on the named suspect by way of a subpoena to appear before him, where the suspect is given the opportunity to answer the charges by way of a counter affidavit. The counter affidavit, of course, is submitted to the prosecutor who evaluates the same. Normally, the public prosecutor will bring the complaining witness, if available, and the suspect on a face-to-face confrontation. And we already know the quarrel will be, this one says, sinuntok mo ko. Sabi nito, hindi, ikaw nauna nanuntok, and so the quarrel now continues right in front of the public prosecutor. And the public prosecutor therefore looks at the complaint, sinumpaang sulaysay sa karamihan ng mga public prosecution offices, and the counter affidavit of the suspect, and determines whether probable cause is present. Meaning whether a crime has been committed based on the provisions of the revised penal code, and whether this named suspect committed those acts constituting the criminal offense. If, on the basis of his evaluation, he is convinced that there is probable cause, then he prepares a resolution. The resolution saying, yes, there is probable cause and there is need therefore to elevate the case now by way of an information, and he does prepare the information bound to be submitted to the judge of a trial court. And there is the judge, and there is the information, which is the finished product of the first half of the prosecutor's role. And the information with the resolution will have attached to it all the available documentary and evidences and affidavits prepared by the witnesses, by the complainant and the witnesses, together with, of course, the counter affidavit of the suspect, and probably medical reports and the police report, and ends up on the table of the judge. The judge examines on his own in order to exercise his duty to determine whether there is probable cause. And if there is probable cause for him now to recognize that a case is about to start before his table, his sala. He issues a warrant of arrest on the suspect so that the suspect, in effect, will come to court and be covered by the jurisdiction of the court. In this particular first half of the criminal procedure, we will notice here two significant ones that we will touch base on. The complaint normally cannot be accepted by the prosecutor unless a barangay certificate to file action is attached to it. And so we will handle this in this particular sharing session, the Barangay Justice System. That's a very innovative feature in the Philippine criminal system. And there will be another slide to determine exactly what particular cases will go to what particular trial courts. Because we know in the hierarchy of the courts, at the trial level, there are two segments or layers of the trial courts. You will have the metropolitan or municipal circuit trial courts, and you will have the regional trial courts, and they have the respective jurisdiction. And that will guide the prosecutor or to whom will he submit his information. This will be covered by another slide. This particular presentation will cover the barangay justice system. Let us now proceed. The barangay justice system has a finished product, and you already saw that in the first half of the criminal procedure. The finished product of the barangay justice system is the barangay certificate to fail action. But this is not the desirable thing that our barangay justice system wants to achieve. Our barangay justice system is intended to allow the reconciliation of differences among neighbors living in the same barangay so that there is no further need to go to court. The intention is to patch up differences, misunderstandings at the level of the barangay so that a good relationship is developed among community members rather than them going to court and become belligerent opponents in life. However, if the barangay justice system cannot patch them up in that one or both feel aggrieved and needs to be somehow compensated, not only financially but also by way of a punishment against the person who injured him, then the barangay justice system, after attempting to compromise and settle the differences, could not have succeeded, and so the barangay issues a barangay certificate to file action. All kinds of disputes among neighbors or among people living in the same barangay have to go to the barangay justice system and, before they go to court. And the control point is the barangay will have to issue a certificate to file action in order that a complaint can be filed before the public prosecutor and also before the information is given due course by the trial court. However, having said that, there are certain disputes that are not subject to barangay conciliation, and we will see why that is so. The first one is where one of the parties is the government or any subdivision, political subdivision or instrumentality of that. Obviously, the barangay cannot be higher than the government, whether local government or national government. And so try to for the barangay Lupon to patch up the government difference with an individual looks to be superfluous, if not ridiculous. And so, if there is a difference between the government and any individual, then that is not subject to barangay conciliation. I was just wondering, for example, this government can be the Bureau of Internal Revenue and it is doing its duty, and the individual gets mad at the examiner, which actually leads us to the second one, where one party is a public officer. We were mentioning a BIR examiner or employee, and the dispute relates to performing his official duty of auditing the tax return of a particular individual. And the individual gets so mad, galit na galit. Can he go to the barangay to drag the BIR examiner to defend himself or to explain the difference? The answer is no. Because when it is a government entity or a public officer in that government entity doing his official functions, they cannot be dragged before the barangay for conciliation. The third one is when the dispute involves real properties, lupa, bahay, located in different cities and municipalities, unless the parties agree to amicably settle their difference with an appropriate lupon. I can imagine, for example, and we will link this up with another one where it may not only be real properties, they may have some interpersonal relations that they differ. And it is possible their properties are situated in that their neighbors, but the boundary between one city to another happens to be between their properties. This is illustrated, for example, here in BF Homes, where we have a long street called Concha Cruz, which on one side is coming from BF Homes Parañaque, and as you proceed, it crosses the boundary towards Las Piñas. And so while that is still BF Homes, it is no longer Parañaque, but BF Homes Las Piñas. And so what if the two neighbors, for example, Juan and Johnny, happen to be living in the same street, Concha Cruz, but Johnny's house is on the Parañaque side, and Juan's house is on the Las Piñas side. In this particular case, if they were quarreling about their wall that they share with each other, then it cannot be a barangay in BF, neither can it be a barangay in Las Piñas that can reference or be the referee, because they belong to different cities. Unless they themselves agree that, okay, let us, the Las Piñas residences, o sige, we'll settle it before your Parañaque barangay, or vice versa. Next dispute that is not subject to barangay conciliation would be those that are involving natural persons. I'm sorry. Uh, the barangay justice system only involves individuals and not artificial beings. And so if there is a difference between two legal entities, two corporations, or an individual and a corporation, then that particular dispute is not subject to any barangay conciliation. Continuing with the disputes not subject to barangay conciliation, I was already mentioning this a while ago, disputes between parties. And this may not necessarily be involving property. It may be interpersonal relations residing in barangays of different cities or municipalities, except when the barangays adjoin each other and the parties agree to settle their differences amicably. I have already touched this earlier. Number six, dispute not subject to barangay conciliation are labor disputes arising from employer-employee relationships. As a matter of fact, not even the regular courts should be involved with employer-employee differences because that is a specialty subject on labor disputes given to the Department of Labor, particularly the National Labor Relations Commission. So, if there is any difference, labor dispute, union versus management, that doesn't belong to the barangay. That has to go to the Department of Labor's National Labor Relations Commission and LRC. Seventh, dispute not subject to barangay conciliation is in offenses involving a maximum imprisonment exceeding 1 year or a fine over 5,000. Well, here is the threshold. If the offense committed is less than 1 year, then you go to barangay conciliation because it may be too petty an issue. Kasakitan, pero hindi naman siguro napakalaki. Or the offense committed did not require a fine more than 5,000. There is no need for barangay conciliation if it is over. But within, that is subject to barangay conciliation. So less than 1 year, 1 year or less, or 5,000 or less. The next dispute not subject to barangay conciliation refers to offenses where there is no private offended party. And for example, vagrancy of a woman caught in the street, you know, effectively can be charged of prostitution. There is no private offended party in prostitution. In fact, probably the prostitute may even be the one who's offended by abusing herself, except she cannot be imprisoned for hurting herself. No, so no private offended party involved in that particular case. Or I remember one time, one of my friends received a subpoena to appear because he violated a municipal ordinance. He was caught urinating in a wall and violating a municipal ordinance against that particular act. So there is no, the only one that was offended is the wall probably. Next, number 9, are disputes needing urgent legal action to prevent injustice being committed. Number 10, criminal cases where the accused is under police custody or detention. So if the offending party, the accused is already is already in the custody of the police officer, then there is no need anymore to conciliate because he's already there. You know, why bring him back to the barangay? Next dispute number 11 that is not subject to conciliation are petitions for habeas corpus by a person illegally deprived of his rightful custody over another or a person illegally deprived of his liberty or one acting in his behalf. Can you imagine a person is already being detained even by the military or police and he needs to free himself because he's not supposed to be arrested. Then if he goes for the remedy of habeas corpus, how can there be a barangay conciliation bringing the person who arrested him and have them conciliate about his illegal detention? Number 12, actions coupled with provisional remedies like preliminary injunction, attachment, delivery of personal property, and support pendente lite. This type of actions require immediate remedies in order to prevent further injury or damage. So, for example, preliminary injunction allows that the action of the other party be immediately stopped. And in that particular case, a barangay conciliation will not be effective in that that person may simply refuse to stop doing what he is doing. And barangay conciliation may not be the correct compulsory move in order to stop that person from continuing to commit his act. Number 13, actions which may be barred by the statute of limitations. Statute of limitations refers to prescription. So that if there is a dispute, civil dispute or what have you, and you bring them to barangay conciliation, it may be the barangay conciliation may be a ploy of one party so that there is a delay, and that delay will cross the boundary so that there is prescription, and the other party that was involved in the conciliation may no longer pursue whatever action he wants to pursue. Next, actions to annul judgment upon a compromise to be filed directly in court. This an example of this is there are two parties that brought their case in court, but out of conciliation or out of the graces of the judge, they were able to patch the differences and arrive at a compromise agreement, and so the case was dismissed. But after they left the court and some things have to be done, one of the parties or both did not want to implement the compromise agreement. And so in that particular case, there again in dispute, there is no need to bring that to the barangay conciliation. What is needed is to go back to the court where the compromise agreement was arrived at, so that the court will be in a better position to resolve what particular portion of the compromise agreement is not being carried out and why. Number 15, any disputes the President may determine in the interest of justice or upon the Department of Justice Secretary's recommendation. And so, ladies and gentlemen, this is the first part of the flow of what is called criminal procedure, which starts with the offended victim and ends up with the judge looking into whether there is probable cause. This particular flow, if you will notice, involves the requirement of a barangay certificate to file action. And what we just took up are those areas where you don't need this barangay certificate to proceed with the complaint even in the absence of that particular barangay certification. Otherwise, all other disputes before they are filed and involving a criminal offense cannot be filed unless there is this conciliation by the barangay and the issuance of a barangay certificate to file action if no compromise agreement or no settlement is achieved. And so that is what we have tried to explain here, that the first major obstacle to proceeding with criminal prosecution is the barangay certificate to file action, which is part of our very innovative barangay justice system to avoid the clogging of our courts with cases. And so, ladies and gentlemen, this is the end of our first slide on remedial law in criminal procedure. We have several subject matters to be taken up, like the next one would be in the area of which courts, trial courts, would have jurisdiction over certain offenses. And so therefore, the public prosecutor, after he determines that there is probable cause, in his resolution and prepares the information, would know where to go, either the regional trial court or the metropolitan or municipal trial court, in filing his information. That is coming up in the next slides, and I hope you continue to tune in and understand this particular series of criminal procedures. By the way, if there are any questions, feel free to respond to comments or questions as we put this up in YouTube, and we will promise to respond to you accordingly. Thank you very much.